I had the coolest job that any electrical engineer could ever have on the ground crew for Solar Impulse 2, the first solar-powered airplane to fly around the world only using the power of the sun. IEEE USA has given me a competitive edge because of their support system. It is so much easier doing something and being out of your comfort zone when you have someone there saying, "You got this." IEEE USA is more than just a network. It's a family.
Good afternoon, everyone, and thanks for tuning in to today's IEEE USA Livestream webinar, USPTO Resources. I'm your host, Jonathan Cho. Today's webinar is the second in a series of webinars IEEE USA is hosting in partnership with the United States Patent and Trademark Office. You can find the link to the full series in our video description or in the comment section below. IEEE USA's goal is to create programming that is valuable, relevant, and of interest to you. As such, we will be sending a short survey to all registrants after this event and would love your feedback. We value your opinions and would appreciate it if you could take a few minutes and share your thoughts. Joining us today is Robin Hilton, who serves as an Assistant Outreach Coordinator for the Eastern Regional Outreach Office at the USPTO, leveraging her expertise in community service and outreach to support the strategic plans and goals of the agency with regard to stakeholder engagement. But I'll let her talk more about that. Welcome, Robin.
Thank you. Hello, everyone, and thank you for joining us today. Just to give you a little bit more background on my adventures with the USPTO, I've been a patent examiner. I've served in that role for almost 20 years, and then I moved over to the International Patent Legal Administration, where I help people with their international patent applications filed under the Patent Cooperation Treaty. So I've had lots of experience with patent examination. But now, today, I'm going to talk a little bit more about resources that are available to inventors and entrepreneurs, and also any business owners. So we will have a short question and answer session after the presentation. Feel free to answer any questions at the time. Hopefully, I will be able to answer all of your questions before we even get to the end of the presentation. So if we're ready, let's get started. Well, I have to first give you this legal note. This is for informational purposes only, and it's not legal advice. So please consult with the appropriate resources for legal authority and guidance on any matters that may arise. Again, this is only for informational purposes and not legal advice. Let's start a little bit about what intellectual property is, although you may know, but we'll do a brief refresher and then we'll talk about all the resources that are available to you. So the USPTO is America's innovation agency, where we are committed to fostering innovation, economic growth, as well as creating a reliable, predictable, and high-quality IP system. The picture here you see is our brand new USPTO Director, Kathy Vidal. She was speaking at the International Trade Association annual meeting. And she is very excited, and we are so excited to have her as our director. Intellectual property has been around for as long as the U.S. has been around. It is founded in our Constitution in Article 1, Section 8, Clause 8. So that tells you that our forefathers thought that intellectual property was very important, and therefore they grounded it in our Constitution. We'll talk about the 4 stages of patents, copyrights, trade secrets, as well as trademarks. So what is a patent? I'm sure all of you know what a patent is, but let's just talk about it briefly. A patent gives the owner the right to exclude others from making, using, selling, or offering for sale or importing the claimed invention, and it is based on a limited term. Depending on the type of patent will depend on the term limit. Patents are territorial. Therefore, a U.S. patent provides protection only in the United States. There is no such thing as a worldwide patent. However, there is a worldwide patent application process, which I mentioned before under the Patent Cooperation Treaty, but there is no worldwide patent. We have not yet been able to establish such a patent, so it is territorial. If you would like to seek patent protection in other countries, you would have to file directly with those countries. What is a trademark? Now, I'm sure all of us know what trademarks are. We've seen trademarks, and we'll talk a little bit about a couple of examples. But what is the purpose of a trademark? Well, one, it is to allow consumers to identify the source or producer of different products and services. Therefore, it helps to build the buyer's protection and helps to them with their decision making. It also encourages trademark owners to provide goods and services of consistent quality and to build goodwill with that trademark. So, what are a few examples? Nike, the Nike swoosh. And believe it or not, Xerox and Ziploc are also trademarks. Although we use those terms rather loosely, they've sort of lost the esteem that some people think of. So Xerox is actually a trademark. We should be using the term, I want to photocopy something. And Ziploc is actually the trademark for a type of bag. And so when we say, I want a Ziploc bag, we say that for everything, but it's really a trademark. And we have to start keeping that in mind, that trademarks tend to lose their value when people use them incorrectly. But what is a copyright? Well, we all know what copyrights are. We know examples of them at least. A play, a musical, music that you hear on the radio or that you stream, any kind of artistic work where someone has authored it and it is fixed on a tangible medium. The Library of Congress administers the registration. However, the USPTO does advise the executive branch on intellectual property issues, including copyright. And yes, the copyright symbol can be used without a registration. That identifies that there is ownership and a publication of that material. So what is a trade secret? Well, that is any information that derives economic value from not being generally known or ascertainable. It can be a formula, a pattern, a technique, or process. What is an example of a trade secret? How about Colonel Sanders' secret recipe for his chicken? Or what about Coca-Cola's formula for a Coca-Cola product? Those are trade secrets. The protection of a trade secret stems from the common law dating back to the 1800s. All states have some sort of trade secret, and most of them are based on the Uniform Trade Secrets Act. So now that we've talked about intellectual property a little bit, let's now talk about the available resources that the USPTO has available for you. When you log into uspto.gov, this is the screen that you will see. And as you can see, you will find inspiring stories of innovation, and this does change periodically. We have easy access to our COVID-19 Response Resource Center. You can find direct resources in your area using these two links. And then if you're a teacher or educator, even a startup, you can go right to the learning resources and find information there. And of course, you can always use the search tool. We do have an expanding innovation hub, and the purpose of this is to help you to learn more about the patent system as well as the trademark system. We want to demystify the systems, provide mentoring programs, and show you where you can find community groups that will help you. This map of the U.S. shows that there are 5 regional offices in total, outreach offices at least. So we do have our headquarters here in the Alexandria, Virginia area. We have regional offices in Detroit, Denver, Dallas, and in the Silicon Valley. The Eastern Region Outreach Office, which I'm representing today, is located at the headquarters in Alexandria. Other resources that we'll talk about will be the Inventors Assistance Center, the Pro Bono Program, the Law School Clinics, the Patent and Trademark Resource Centers as well. All of these are available at uspto.gov. In every state, you can find resources available to you. Since we're located in Virginia, I just happen to have the Virginia location here on the screen. But as you can see, you can find information regarding patents, trademarks, IP policy, resource centers, anything that you're looking for available in Virginia will be located here. And again, you can find anything located in your particular state. Once you get to the inventor and entrepreneur resources, you will find this screen. You can get started here. It talks about the types of IP protection, which we've mentioned before. You can attend a free training. And there's also information on patent basics as well as trademark basics. This is a helpful tool that'll help you get started before you even apply for your patent or trademark application. This will help you to get help once you do apply. Free resources and services that are near you, how to find a patent attorney or agent, and it'll help you to identify if you should actually have a trademark attorney. So as you can see, there are various tools here that are available to you. Information here on startups, how to license and sell your IP, if you need to change the patent ownership or change your trademark ownership, as well as other federal resources under the Entrepreneur Services. For those of you who are starting your business and you need help with starting that, again, you want to access and protect your IP. This is something that we encourage all of our business partners to think about as part of their business plan. Don't wait until you actually start your business, but think about what IP protection you need as you're starting your business. You want to think about protecting your IP in the US. Is this something that you need to protect abroad? And how to fight costly counterfeits. Again, all of this is about protecting your intellectual property. Again, we have information on how to develop your business plan, links to the Small Business Administration, as well as small business development centers, which can help you as well. This is valuable information for those of you who are intending to start a business. We also have our information on how to find funding, again, through the Small Business Administration, where they can provide you with resources for grants, as well as assistance in how to apply for those grants. And then, of course, how to engage experts. For those of you who are visual learners and you like to see things, we do have a USPTO video library on YouTube, so you can subscribe to our YouTube channel and find all kinds of information and videos regarding patents and trademarks there as well. One other resource that would be beneficial to you is to subscribe to our patent alerts. Here you will get information regarding anything that you're looking for. So you may not want to know about patents and trademarks and copyrights, as well as the monthly review, but then again, you might want to. So you can subscribe to any or all of these. One of them that I would highly suggest that you subscribe to if you are an entrepreneur is the Inventor's Eye. That will give you information about what inventors are doing. It will have some resources as well as inspirational stories of inventors and their journey. Some of them even are kid stories. So that's always very inspiring. So if nothing else, subscribe to the Inventor's Eye. But of course, I would subscribe to all of these because it helps you to keep abreast of changes that are happening in the intellectual property field. For those of you who would like to attend a class, you can do so by going to our events page. And each month it's updated to let you know what classes are available. Right now, most of these are still virtual. At some point, some of them will be in person again, particularly for those resources in the centers outside of the Washington, D.C. area. So for the other regional offices, you will probably have some in-person events coming up soon. But in the meantime, sign up for some of their virtual classes because they can be very helpful for you. Not only do we offer classes, but we also offer information regarding entrepreneurs. Yesterday, there was a program on Asian American and Native Hawaiian Pacific Islander Inventors Innovation and Inventorship Program. And part 2 will be coming up again soon. So there are all kinds of things that you can attend. There's also information on our DocX filing training. So you can find information regarding that. So when you get ready to file your patent application, you'll know exactly what you need to do step by step. And of course, if you need a little help, we do have our Inventors Assistance Center. This is manned by former supervisory patent examiners and experienced former primary examiners who can answer general questions regarding the examining policy and procedure. Again, they're not allowed to give you legal advice, but they can help to guide you through the process. And that center is open Monday through Friday, 8:30 a.m. to 8 p.m., except for federal holidays. And there is a toll-free number that you can call. Likewise, there's also a trademark assistance center where they can provide you with general information regarding your registration process. They too are open from 8:30 a.m. to 8 p.m. Monday through Friday, except federal holidays. They have a phone number as well as an email address for those of you who would like to just get something in writing. If you have a quick question and you don't want to sit on the phone, you can always email them and they will respond back to you in kind. For those of you who are going the patent and trademark patenting process on your own, you'll be calling our Pro Se Assistance Center. This center is open from 8:30 a.m. to 5 p.m. Monday through Friday, again, except for federal holidays. There is an email address where you can email them. There's also a phone number where you can speak to someone, as well as a web page to get more information. You can get more specialized assistance with this program, particularly if you are a pro se inventor. Again, those of you who will be going alone without a registered patent agent or attorney, and they will help you and give you more hands-on advice. Again, not legal advice, but they can help you with the process a little bit more because we know that you are doing it all by yourself, and there's nothing wrong with that. The USPTO Pro Bono program is something that we highly recommend for those of you who are eligible to participate in it. The program participants must have an income 300% below the federal poverty guidelines. It's a nationwide network that assists these financially undersourced independent inventors and small businesses. Okay, so we do have registered patent pro bono attorneys, agents, and patent pro bono law firms. As you can see, this is a nationwide program. This lists all of the centers around the country. So there is one probably within a few hours drive of you if you have to travel a little bit. Might not have to travel that far, but there are resources all across the country, these pro bono programs. There's also the law school clinics. And the USPTO has partnered with various law schools around the country where students are allowed to participate in the law school's clinic, and they practice for the USPTO under the guidance of a law school faculty clinic advisor. And you can find information at this link on our website. One other resource that may be beneficial to you is the Patent and Trademark Resource Center. Now, this is a nationwide network of public, state, and academic libraries. They have been designated, and they partner with the USPTO to disseminate patent and trademark information, and they can help you support you in your intellectual property search. If you're looking for something and you're not quite sure how to begin your search, you think you have an idea, then you can reach out to one of the PTRCs in your area, and they can help you to start the search process to guide you through what you need to do in order to do a prior art search of your invention prior to submitting your applications. One of the other things that we have offered is reduced patent fees. So if you're a small entity, you can get 50% reduction in your patent fees. You must be an individual or a small business with less than 500 employees or a nonprofit organization. If you are a micro entity, meaning that you have filed no more than 4 previous applications and your income is not greater than 3 times the median income, you have not assigned your application to any other micro entity, then you may be eligible for a 75% reduction in patent fees. I will have to tell you that this one does require a form to be submitted with the application. Each application must have its own form submitted in order to establish microentity status. You cannot expect us to transfer that form from one application to another. So each of the applications that you file, so it says no more than 4, Each one must have its own microentity form in it in order to establish microentity status in the application. And if you need your patent application processed quickly, we do have a track 1 prioritized examination process. You can find more information on that at this link at uspto.gov. What other resources do we have available to you? Well, we have the utility patent application guide at this link. We have patent process, a search guide to help you with your search, because you may want to do a prior art search before you file your application. We have, again, as you saw before, resources for inventors and entrepreneurs. We do have our Pro Se Assistance Center for those of you who will be going it alone and seeking patent or trademark protection. I will say that you will have to decide whether that is in your best interest. To do it alone, you may need to have an attorney or agent to represent you. It's not required, but you have to decide that on your own. And sometimes you can consult with an attorney prior to submitting your application, and they will often do that for free to get some advice and then determine whether or not you want to sign with that attorney or agent. And again, there's microentity information available to you as well. Excuse me. So as you all know, in 2020, COVID-19 hit the world. And so the USPTO had to decide, how are we going to handle COVID-19 in applications? So we have several prioritized examination pilot programs that are still in effect. So the U.S. has, excuse me, I don't know what's going on in my throat here, will grant prioritized examination to patent applications that qualify for small or micro entity status without payment of typical fees. And the aim is to provide this final disposition of applications within 6 months of the applicant providing their information to the USPTO. So this was launched in 2020, and it will go until midnight of June 30 of 2022 in terms of your patent prioritized examination pilot program. The website will detail criteria for the pilot program, how to request participation, and any other public announcements or comments and questions that you may have. There's a frequently asked questions section, and you can find that here at Explore the COVID Prioritized Examination Pilot Program from the USPTO website. The trademark also offers a prioritized examination program. To date, there has not been a cutoff time for when this will end, so you'll have to keep abreast of the trademark prioritized examination program by visiting our website as often as necessary. In both cases, the office will decide when to end the program, and they will let the public know prior to ending the program. Again, from the same section of the COVID-19 prioritized examination pilot program, you can get a link to the trademark prioritized examination program. And this screen just gives you information on how to get more information regarding the trademark prioritized examination program, questions that you may have, as well as how to reach the Trademark Assistance Center. One other thing I'd like to talk about with regard to resources is the Patent Trial and Appeal Board, where we're having remote interviews and hearings. It started in March of 13 of 2020. It is still in effect. And again, once they go back to in-person interviews and hearings, you will be notified prior to that happening via our website and public notifications. The Patent Trial Appeal Board is for those patent applications which were rejected by the examiner, meaning that they will not be evolving into a patent, and the applicant decides that they want to have a second opinion. The same thing with the Trademark Appeal Board. They review trademark applications that have not transmitted into a trademark, and where the applicant would like to have a second opinion from a board of judges. So both of these are right now having remote hearings. You can find more information regarding this. They can be done by telephone, via video, or telephone for the oral hearings for the AIA trials. So again, you can find information regarding any patent or trademark appeal board by visiting our website. Both the USPTO and the EPO, as well as the USPTO and the JPO, the Japanese Patent Office and the European Patent Office, have signed agreements in terms of unity for these applications during this time of COVID. There are certain waivers that are required, and you can find more information about this regarding handwritten signatures that's been waived. These signatures will be accepted, and there's allowed for the filing of patent applications via electronic filing system, which was not available prior to COVID-19. And again, any changes in this will be acknowledged via our website, as well as through our any other communication that the office feels necessary to have our public know about. And lastly, we realize that the effects of COVID-19 has been extraordinary. So they have permitted patentees to file initial patent term extension applications that meet certain criteria via EFS Web and the Patent Center, and extended the time period for petitioning for certain rights of priority or benefit, and waived any associated petition fees. Again, any changes of this will be made publicly available to you prior to it taking effect. And that concludes the presentation. Hopefully that I've answered any questions, but if there are questions, I would love to have them at this point, and we will stop sharing my screen so that I can see you all, and we can talk about any questions that you may have.
Fantastic. Thank you, Robin. So, folks, we will now open up the floor for questions from our audience. Go ahead and ask your questions in the comment section, and we'll load them onto the stream for Robin to answer. Robin, before we get on to our audience questions, I do have a couple of my own that I'd like to ask.
Okay.
So my first question, how can I find out if I need a patent, trademark, or a copyright? Is there any specific resource that provides that information?
Well, I'm going to key in on the word need. It's not necessarily a factor of whether you need to file a patent. The question is, do you want to protect your intellectual property? So we don't have anything that tells you that you need to file a patent, but there is information to tell you of what you can do in order to do a prior art search to see if there is something that is already similar to what you're doing, to what your invention is, or if you just want to find out what is out there in the public domain. So there is a search. So we don't have anything to tell you that you need to file, but we do have information to tell you how to determine if you have a patentable subject matter or trademark that you can register.
Gotcha. Thank you for that.
Mm-hmm.
My next question, any resources for teachers and educators, and what kind of resources are available?
Oh, absolutely. We do have resources for teachers and educators. As a matter of fact, our Office of Education and Outreach offers a program every summer for teachers. And you can find information if you go to the website. At the top of the page, there is a link that talks about educators and teachers. If you don't see that, you can always just type in the search tool, teachers and educators, and you'll find tons of information. As a matter of fact, they're also in the process of launching a new web page that will provide more hands-on guidance for teachers that they can use in their classrooms, which is very exciting.
That's great to hear. Thank you so much for that insight.
Mm-hmm.
And we'll now move to our audience questions. Our first question, David asks, is there a fee schedule available for patent processing?
Yes, there is a fee schedule. So the easiest way to find it is to go to uspto.gov, and in the search bar, type in fee schedule, and then that will give you all of the fees for everything: plant patents, utility patents, the international filings, as well as the I just lost the word that I was looking for. The maintenance fees for your patent applications, for your patents. It'll give you all the fees that we require, as well as any petition fees.
Great, thank you. And
Mhm.
David, we've also included the link to that
Mhm.
specific page Robin mentioned in the comments tab. So if anyone else is interested, feel free to access that. Thanks for the question. This next question, one second.
Mhm.
Audience member, how widely used are the patent assistance and micro entity programs?
Well, I don't have any data available to me right now, but we do know that people use our micro entity programs. In my role as a in the International Patent Legal Administration, I do see those patent applications that come through with micro entity forms in them, where people are. So I know people are using them, as well as patent assistance. Our pro bono programs are thriving, as well as the PTRCs, where people are going to get information. So we know that patent assistance is being widely used. I just don't have specific numbers that I can give you.
No worries. Thank you for that. And thanks for the question. This next question, John asks, can you discuss anything you know about classified patents? Any insight, Robin?
So I'm not sure if this is classified in terms of secrecy. If that is the case, I know that we do have an art unit. So it's the way the PTO is structured. Each group is called the art unit that reviews certain patent applications, and we do have an art unit that deals with the secrecy codes and secrecy of certain applications. So I don't know anything about those. If you're talking about classification in terms of how they're classified and how they're grouped, then yes, we're now using an AI to help with making sure that patent applications are going to the correct art unit based on the examiner's experience with a particular art, particular invention. We call it art, but they're particular inventions.
Hmm.
So hopefully
John,
I
I hope.
answered that question. I try to answer it both ways depending on what
Mhm.
classified meant. So
Gotcha. Thank you, Robin. And
sure.
thanks for the question, John. I hope that answered your question. This next question, what tools do you offer for prior art searches?
Okay. That's a great question. So we originally had two different tools that were available on our website for searching. We now have a new tool called Pub Patent Pub, and it is more related and more in line the way that patent examiners use the tool that they use for searching. So that's a brand new tool. There are classes available on our website. So you just go to the events page, the next schedule a class. I believe they're offering them twice a month. One to get started, a new beginners class, and then another one for um, advanced searches. So you can find that information. But that's a great question. That's a brand new tool that will help you to find prior art that's closely related to the way the examiners find them as well.
Fantastic. Thank you.
Mm-hmm.
Um, this next question, Henry asks, what what exactly does it mean in the agreement between the USPTO, Japan, and Europe? Is that due to COVID, and will it end once COVID ends?
Okay, yes. So there's a multi-part question. So yes, that particular agreement was dealing with COVID. So there are agreements between the U.S., Japan, and Europe regarding COVID. It's just a unity saying that we understand that there's a global pandemic, and we're going to do all we can to make sure that we get these patent applications processed as quickly as possible. Now, the USPTO, Japan, and Europe, the European Patent Office, are also part of what we call JP5, which is three of the largest five patent offices around the world. And so there also are agreements for other things as well, as part of the Patent Cooperation Treaty, as well as the Madras Protocol, as well as the Hague Treaty for International Designs. So there are various agreements. But yes, the one specifically that was mentioned in the slides was dealing with COVID. And I don't know exactly when it's going to end. Again, anytime that there's going to be a change in ending programs, then the public will be notified ahead of time.
Great, thank you, and thanks for the question, Henry. And we actually do have one bit of a statement from one of our audience members. Michael
Mhm.
says that he's tried the new patent tool and it's awesome once you get used to it. So
Great,
thanks for that insight, Michael.
great,
Definitely hope
great.
more of our audience members and our IEEE members will be able to use that.
Hmm. Hmm.
Michael also asked, is there a section for assistance on European and Japanese patent filings within the USPTO site?
Unfortunately, no. The only thing that we have in terms of other countries is we have a link to WIPO's website, the World Intellectual Property Organization. We have a link to their site, and then you can get information from there. But we don't have anything specific on our site to the EU or to JPO.
Robert, this next question, Robert asks, if you file a patent with the USPTO, is it only protected for product sales in the United States?
Yes, yes. It is territorial. Patents are territorial, so they only protect you in that particular country. So in this case, if you wanted to sell something outside of the U.S. And you wanted to protect other people from reproducing your product, you would have to get a patent in that other country as well. You can sell it, but that doesn't mean that you won't have knockoffs.
Mhm. So I do have a quick question about that. Is
Mhm.
there a difference between is there such a thing as international patent protection from the USPTO, or would they have to go about getting that patent in another country, like you said?
Right. So you'd have to get the patent in another country.
Hmm.
So I had mentioned the Patent Cooperation Treaty, and what that is an application process. So which allows you to have an extended period of time to decide if you want to seek patent protection in other countries. And you can use that one application to enter into those other countries rather than having, let's say you wanted to file into 5 countries. You would have to file 5 different applications. But if you use the Patent Cooperation Treaty, it would be one application that you would use in those 5 different countries. But you'd have to get protection in each country separately.
Gotcha. Thank you for that
Mhm.
insight.
Mhm.
This next question, can an engineering process be patented?
I'm going to say it's going to depend on what the process is, but we do have patent applications and for processes, methods of manufacturing, methods of use, as well as the product. So it is possible that you could get a patent on your engineering process.
Great, thank you.
Mhm.
This next question, one of our audience members asked, could you describe the current state of software patents right now?
Okay, so software patents is out of my wheelhouse. I will tell you that. I don't know exactly where that stands. I know that some of our stakeholders have talked about in terms of software having trouble getting patent applications in terms of what we call Statute 101. So that's something that if you're interested in, you'd really have to talk to a patent agent or attorney. I think you would have to get, and that was probably one of the areas where I would recommend strongly that you have a patent attorney or agent to help you with your patent application.
Great, thank you. This next question, Samuel asks, can how can a small business claim the 50% fee discount, and is there a certain document that they might need?
There is no document that you need. You just have to pay the fee initially when you file your application. You pay that initial fee to declare that you meet the requirements of that discount eligibility. But with the micro entity, there is a form that is required, and that form is available on the website.
Great, thank you.
Mhm.
One of our audience, MJR, asks again, can a trademark be granted before the product is launched?
I'm going to say yes. The trademark is based on, so the trademark will be granted based on the search that's available to the examiner, to the trademark attorney. So you may want to trademark it before you launch it. I would probably say that might be the best thing, but again, I can't give you legal advice. But yes, it can be granted prior to launching a product.
Great, thank you.
Again,
Hope that,
again, I want to go back to what I said before. Part of your business plan should be, how am I going to protect my intellectual property before I start my business or while I'm in the process of starting my business? So you need to think about if you need to trademark something, if you need to get a patent application filed and not wait until you've already launched your business.
Great, thank you. MJ, hope that helps. If you have many patents owned by your employer, can you qualify for a micro small entity program for your own ideas once you retire?
That so a lot of employers, I'm trying to figure out the best way to say this. A lot of times employees sign over the rights of their intellectual property over to their employer. So therefore you're not the patent owner
Mm.
because you signed over your rights. So therefore it would see that's kind of a tricky question because you're not the patent owner. However, you are still an applicant or an inventor named on the application. So I'm not sure if you would still qualify for microentity status. What I would suggest you do is to call the Applications Assistance Center and ask them to be sure. I don't want to give you the wrong information. I'm not sure about that one, but it seems to me that there's a little bit of a gray area there.
So we did get some information from our colleague Albert. Patents filed as an employee of a corporation does not count against
Okay.
microentity status.
Okay, great.
Thank you, Albert. And we hope that answered your question.
That's why it's always good to have somebody else to help you in the background.
Mm-hmm. This next question, Frank's asked, what's the approximate acceptance rate for patent applications?
All right. What you can do, we do have a tool on our website where you can look at the acceptance rate. You can also look at the time it takes to get for prosecution of a patent application as well as trademarks. You can find that information on our website. There's several databases that will show you that tool, and perhaps Albert can find that and put it in the chat for us.
Yeah, so stay tuned, Frank. We'll get you that answer as soon as we can.
Mm-hmm.
In the meantime, George asks, does the cost reduction for the mini program relate to USPTO fees only or attorney fees as well?
Right. So the fee reduction that we talked about is only for the application process, not for the attorney fees.
George hopes that, or we hope that answered your question.
Mm-hmm.
This next question, why does the Patent Office have offices in other countries?
Well, the United States Patent and Trademark Office does not have offices in other countries. We have 4 regional offices in the U.S., but the other patent offices belong to those other countries. We do have attachés, which are located in other countries that are USPTO employees, but we don't have a patent office outside the U.S.
Makes sense. USPTO is
Right.
United States, so
Right.
yeah. Thank you for clearing that up.
Mm-hmm.
Dieter asks, why is there a time limit for patent prioritized examination program for COVID-19 since COVID-19 isn't over yet?
Well, originally they had limited it to 500 patents, and then they decided to extend it to June 30 of 2022. And I honestly do not know why the time limit was set for June 30.
It's also very possible that it might just be a rolling
Mm-hmm.
basis, so could
Right.
continue on after that date as well.
Quite possibly. Quite possibly.
This next question, Keith. Oh,
Oh,
Keith. That's per me, I guess. Keith, you will probably get more information about that in the feedback email you receive after this webinar is over. So stay tuned. Michael asks, can the USPTO improve classification tools for CPCI identification and search? They're a bit
okay.
they are a
Difficult.
bit
Yeah.
difficult to navigate.
Yes. So the classification tools for CPC, you're not the only one who it's not thrilled. Well, use not the word not thrilled with those. Some of the examiners have felt that they are a little bit cumbersome as well. They are trying to improve it every day. There's a certain section of our office where they're devoted only to the classification, and they're working on that to make sure that applications are going to the right people based on the classification. The CPC structure, as you know, was changed maybe 7 years ago from the U.S. patent classification system that we used to use that seemed to be that most of us were used to and we really liked. Then they changed it to CPC. So they're working on that, continually trying to update the process and making sure that applications are going to the right people and that they're making sure that the classification breakdown is as succinct as possible. So that's an ongoing process.
Great, thank you. This next, I guess, comment statement, Kit's mentioned that I asked the question. I'm assuming regarding the employer and
Okay.
microentity question, and the USPTO had apparently said that they do qualify as an inventor of microentity. So
Awesome.
thank you for that insight, Kit.
Yes. Thank you, Kit.
Um, this next question, I guess regarding the outside so former Silicon Valley regional office head is now located out of the country. What is his role? Is he still part of the USPTO? Um,
Um,
if you have any insight on that, or does his international status affect his role at all?
he is either an attaché or he may have moved over to a. I can't remember his name. I do recall hearing about him. He is still part of the USPTO, I believe, but his role is different. He's not. So he's not heading up an office outside of the U.S.
Hmm.
I might
Okay.
have to get the information and forward it to Jonathan later, and then he can get the information to you later.
Hmm. And I've just been informed that our audience member Parnell is an IP attaché.
Attaché, right?
So thank you
Mhm.
for the question and for the insight. Brick asks, if a patent item can also be copyrighted, are there cases where a patent holder and a copyright holder are two different entities? If so, where does the jurisdiction lie in these cases?
Okay, so a patent is for an invention, such as a process of making, a process of using, or a product. A copyright is for something such as music, a play, a book. So they're different. So you can have a copyright and a patent, but they're on two different things. So I don't know of anything that can be both patented and copyrighted at the same time. That's by definition, they're separate entities.
Gotcha. Thank you for that insight, Robin. Um, Also, a kit has provided us with some more insight. I'm trying to figure out if if the two comments were in order.
Yes.
Great, thank you for that insight, Kit.
Mhm.
Sorry, our comments sometimes get rearranged,
Yeah.
so we was trying to make sure that we're reading them in order. But thank you for that insight. I think that's it for our comments right now. We'll give it a couple more minutes for questions from our audience.
I do appreciate the questions. They've been very, very thoughtful and thought provoking. Hopefully, I've answered them all to your satisfaction.
Oh, so we do have a question from one of our audience. David asks, would it be possible to give a short demo of a patent search tool while we're here, or is there any insight that I believe we've given the links for those patent searches
Mhm.
as well in the comment section, but Robin, would you be willing to provide that, or?
Well, I'm not proficient at the tool. I've used it once or twice, but I'm not proficient at it. So I don't want to confuse anyone. But we do have some classes coming up. I'm going to open up my web browser.
In the
Excuse me.
meantime, I will provide that link in the comment section again for our audience members who might have not seen it the first time.
I'm going to just check our events page. I think we have some coming up this month. Excuse me, next month. And what we can do, if there is enough information, interest, we can always provide training for your group
Absolutely.
as well.
And I should mention to our audience that we do have a webinar on patent searches on August 17th. So if you would like more information on that, you can definitely tune into that webinar, which I will provide the link to in the comment section below as well. Please stand by. In the meantime, Robin, we do have another question. Um, MJ asks, is there a design patent for user interface?
I'm not clear on the question. I don't know what you mean by for user interface.
Yeah, MJ, if you could provide a little bit more insight, definitely we will try and give as much insight on uh, as we can.
Right.
In the meantime, this next question, for income considerations, do pension and social security qualify as their unearned incomes?
Wow, I tell you, some of these questions are really challenging me. That's not in my wheelhouse. If that is your only source of income, then that would be your income. Um, if you're still working and you're getting, well, you wouldn't be getting a pension if you're still working. You could get Social Security and still be working. I honestly don't know. You can contact someone in our micro entity department about that to be sure.
And folks, I've just included the registration link for our patent searching webinar on August 17th below. And Albert has provided with some insight. User interfaces are possible for design and utility patents. So thank you so much, Albert. And MJ, I hope that answered your question. Let's see. This next, uh, this next question, John asks, I did read that in the US or possibly some other country that patents for medical and pharmaceutical material are longer because of the time required for trials. Is this still true?
Hmm. The patents for medical are longer because of time. Okay, so patents are 20 years from filing, regardless of the type of patent. So a utility patent would be 20 years from filing. Plant patents and design patents have a different time frame, but any utility patent, which would include medical or pharmaceutical material, is 20 years from the time of filing. And our laws are different than what they are in other laws. So I don't, I can't tell you what the other countries' laws are determined of how long their patent protection lasts. But for us, utility patents are 20 years from filing.
Great, thank you, Robin. And thank you for the question, John. As Robin mentioned, these definitely are a lot of these questions are very challenging, and that definitely tells us that our audience are really engaged in these
Mm-hmm.
kinds of topics. So, we're really looking forward to seeing a lot of you at our future, our upcoming USPTO webinars as well. Again, great questions. Thank you for all the insight that our audience has been able to provide. Um, this next question, Frank asks, how much of a problem is a foreign entity that uses IP from a U.S. patent?
Well, from what we've been reading in the news, is a problem, particularly from China. That's not saying that it doesn't happen in other countries. Again, I can't give you any particular numbers, any specific numbers, but we do know it can be a problem in certain countries, which is why it is important to protect your intellectual property in other countries.
Hmm. Great, thank you. And I've just been told that medical patents can be extended where there's a delay in the FDA regarding
Extension.
the extension. So thank you again, Albert. We really appreciate you helping us from the background. Folks, we'll take time for a couple more questions. This next question, George asks, does the cost reduction for the micro program relate to US? Oh, actually, I think we
Yep.
had that question already. George, if you so I believe Robin said that it only applies for the USPTO piece. Is that correct?
Yes. Yes.
So, George, there you go. Thanks for the question. Oh, this next question, Andrew asks, are there legal bodies which help in the commercialization of issued patents?
Well, there may be, because we're not an enforcement or we don't deal with commercialization. I don't have any references, but what I would do is I would suggest that you contact NIST, it's a government agency, contact the SBA, Small Business Administration. Perhaps they can help you to guide you to by entities that can help you with commercialization of your issued patents. But at the USPTO, we don't have that capability to help you with that.
Gotcha, thank you. And while we are waiting on at least one more question from our audience member, I do have a question on my own,
Okay.
Robin.
Mhm.
So when filing for a patent or applying, does one need to hire a lawyer or an agent in that process at all, or and does the USPTO help or provide any assistance regarding that?
Okay. So it is not required that you have an agent or attorney to represent you. We do have a list of registered folks that are registered to practice before the USPTO. So you can find that on our website, that list. You could also talk to people in various inventor groups around the country. If there's an inventor group near you, they can definitely recommend an agent or attorney that they've used before. It is not required that you have one. Some of the applications are probably best prosecuted by an attorney, depending, especially if it's something that's very specific or very high tech. You might need that. Again, our applications assistance center, our pro bono program can help you with finding an attorney that can help you if you qualify. Again, I believe it's less than 300 times the the medium income rate. You can apply for the pro bono program where you can have someone to help you. So we do have resources available to help you either to file the application and prosecute it yourself or to help you find an attorney that can help you with that. But an attorney agent is not required.
Great, thank you.
I have helped when I was a patent examiner. I did help pro se applicants with their applications.
Fantastic. So we'll take these last two questions that we have from Michael and MJ. Michael asks, does the patent examiner use, I'm sorry, I can't pronounce
Yeah,
this.
it's a
Uh,
search tool, I believe.
Gotcha. For CPC and prior art search or primarily USPTO search tools?
So the examiners use a search tool that's provided to us. However, they can use other search tools, and it really depends on the art. Um, for me, when I was a patent examiner, I examined closures, receptacle closures, whether it's a bottle cap or a sippy cup or things like that, or a trash can lid. So most of my searches were based on the U.S. system that I was searching for. If it was a wine bottle stopper I was looking for, then I might look in the French patent applications because they have a lot of wine bottles and things like that. So it's really art specific as to whether or not you need to use other search tools other than what the examiners are provided through the U.S. But yes, you can use these other search tools. Again, it's very art specific. And for
Fantastic.
instance, I didn't use a lot of non-patent literature, but other um, disciplines would use a lot of non-patent literature for their searches and in their rejections.
Mhm. Great. Thank you for that insight. Michael, we hope that answered your question. So MJ asks, do micros qualify for pro bono?
Again, if you reach, it's that if you meet that criteria of not having filed more than 4 applications previously, and you meet the threshold of the income, then you should be able to have pro bono assistance. So you just have to meet all the metrics.
MJ, we hope that answered your question. So Robin, we actually
Mhm.
just received one last question, if you don't
Okay,
mind
sure.
answering it. So this last question, Samuel asks, if we release the product commercially, which he states is fiber optic lens, it's already been supplied, but we want a patent now, is it okay?
Well, there is disclosure that you have to be concerned about. And in this case, it sounds like you've already disclosed your patent, your invention. Um, you would have a difficult time with the patent because in the U.S. we have a certain period of time that you can disclose your information. Certain things, if you disclose it in public, you can't get patent application. You can't get a patent for that.
Mhm,
So in your case, you may not be able to get a patent.
mhm.
I
And
don't
we,
want to, you really have to be careful with disclosure. Okay,
mhm,
in public disclosure of your applications. That's why we tell people, if you have an invention, you have an idea, if you talk to a patent attorney agent about it prior to filing it, that's one thing, but you don't want to disclose it publicly in an open forum.
and we actually we got another I guess, statement from one of our audience member who just said the same
Mhm.
thing. Can't patent what's already in the public domain. So
Mhm.
definitely got to watch out for that. Thank you
Yep.
so much for that question. And this one last thing from our colleague Albert regarding the pro
1 year.
bono. So apparently, income requirements are more strict for pro bono than for micro entities. So MJ, we hope that provides you with a little bit of insight. And apparently, there's a 1 year statutory bar from getting a patent after disclosure.
Mhm.
So again, thank you so much, Albert, for your assistance.
Mhm.
And so, folks, we are out of time, unfortunately. Robin, thank you so much for giving our audience your insights into the different kinds of USPTO resources our members and everyone can access. And thank you to our audience for providing your great questions um, and for tuning in. As mentioned at the beginning of the webinar, we will be sending a short survey to all our registrants after this event and would love your feedback. If you would like to access this webinar will be archived on our Facebook, YouTube, and LinkedIn channels afterwards. Follow us at IEEE USA on social media to stay updated on future webinars, and we hope you all have a great rest of your day.